3 closed their respective cases without leading any evidence. I should mention that Advocate Weinhardt handed in a document with the consent of the state which was endorsed as Exhibit J. It was a statement of the erstwhile accused Mr. Maré, who pleaded guilty to the charge of murder before my brother Masopa J. 48. This concluded the evidence which was presented in this court before me. The parties sought that the matter be postponed for them to prepare heads of arguments, which the court acceded to. 49. The court was furnished with heads of arguments from all the parties. I thank all the respective counsel who prepared heads of arguments for their contributions. Heading legal submissions by the parties. 50 in square brackets. Each of the legal representatives of the accused submitted that the accused should be acquitted for various reasons. The prosecution, on the other hand, submitted that all three accused should be convicted of murder. 51. On behalf of accused number 1, it was submitted that there was no evidence that he was in the room where Caiphus was shot. He did not testify at the inquest. According to his counsel, there is not a shred of evidence linking him to the shooting or the killing of the deceased. On behalf of accused number 2, it was submitted that the court should find that Mr. Nyakane's evidence should be rejected, as he did not mention in his statement that he could identify any person who entered the room. However, at the trial, he testified that it was accused number 2 who wore the clothing he described and subsequently saw his face. The raison d'etre of the arguments on behalf of accused number 3 was that he was not warned about his rights to self-incrimination at the inquest hearing. And for that reason, the inquest hearing should be declared inadmissible in respect of that evidence. Reliance for this views was premised on the decision of State v. Lawane, spelled L-W-A-N-E, 1966, Volume 2, S.A. 433 in brackets capital A. I will revert to this aspect further on in this judgment. Heading Evaluation of Evidence, 51. At the outset, permit me to mention certain trite principles which are worthy of repeating and which the court is enjoined to follow. 51.1. In determining the innocence or guilt of an accused, the court will consider all the evidence presented. As determined by Nugent J., as he then was, in S v. Van der Meyden, 1999, Volume 1, SACR 447, in brackets capital W, at 449, alongside the letter small j, to 450, alongside the letter small b. 51.2. The onus to prove the accused's guilt lies squarely upon the state. See R v. Difford, 1937 AD 370. R v. M, 1946 AD 1023. And S v. Chabalala, spelled C-H-A-B-A. 2003, Volume 1, SACR 134. 51.3. Evidence of a single witness will be viewed with caution. See S v. Souls and others. 51.4. A conspectus of all the evidence is required. As was stated, the compartmentalized and fragmented approach of the magistrate is wrong. See Traynor v. S, 2003, Volume 1, SACR 35, SCA, at paragraph 9. Para 52. In the course of this judgment, I will allude to the doctrine of common purpose, which the prosecution relies upon, comma, the right of an accused to remain silent, comma, the admissibility of the inquest proceedings, comma, albeit that the record of the inquest was incomplete, semicolon. The question of Mr. Maré's Section 112 plea statement, which was handed in as Exhibit J. 53. The prosecution sought a conviction against all three accused based on the doctrine of common purpose. In its summary of substantial facts, it alluded excuse me, to the accused and other officers having taken a decision to execute the deceased. This decision was taken at the police station at the briefing. The crux of the state's case is that the purpose of the police attending the Nyoka household was to perpetrate an assassination and not to arrest Mr. Nyoka. In furtherance of its case, it sketched the historical background of how the police, and in particular the security forces of the apartheid state, consisting of the security police and the defense operatives, operated. Mr. Weingart, in his address to me, also alluded to the fact that one must consider the situation in the country at the time. I think I've dealt with this when I referred to the profound and erudite words of Muhammad D.P. in the Asapo case. To this end, the evidence of Dr. Rousseau was helpful and insightful. She testified how the security police and defense force operated with impunity in apprehending the so-called enemy of the state. In some instances, they resorted to eliminating people who opposed the unjust system. She testified that in order to kill an opponent was not spoken of in literal terms or in plain language, but was euphemistically used. Words such as, and phrases such as eliminate, send him to the cemetery, were commonly used to kill opponents of the racist regime. 54. I will start off by analyzing the evidence before me against the backdrop of what common cause facts in this matter are, namely, 54.1. The deceased was fatally shot on the 24th of August 1987 by the police who raided the Nyoka premises. 54.2. That Mr. Nyoka died as a result of multiple gunshot wounds inflicted on him on that day. 54.3. The three accused and Mr. Marais were present at the Nyoka residence on that tragic morning, together with other police. 54.4. Mr. Marais, accused 2 and accused 3, entered the deceased room after breaking the door to gain entry. 54.5. According to the inquest record, Mr. Marais shot the deceased 4 times and accused number 3, Mr. Stander, shot the deceased 5 times. 54.6. 3 other young men were in Mr. Nyoka's room prior to the police entering the room, one of whom was Mr. Nyakane, who testified before me. 54.7. Marais, accused 2 and accused 3 testified at the inquest, which was held at Benoni Magistrates Court. 54.8. None of the police who participated during the raid on the 24th of August 1987 applied for amnesty at the Truth and Reconciliation Commission. 54.9. No independent witnesses saw the shooting of Caiphus, the only account of the shooting being that which was during the inquest hearing and what appears on Marais Section 112 plea statement, Exhibit F. Heading: the issue of the inquest. 55. On behalf of accused 3, both Mr. Oakes and Advocate Weingart, who appeared for him at different stages, submitted that the inquest record should not be admitted against Mr. Stander, since he was not warned of his rights to self-incrimination. They submitted that in line with State v. Lumani, Supra, the inquest record should be ruled inadmissible against accused number 3. I made a finding in this regard, and I provisionally gave my reasons at that time. Those reasons, without repeating them, should be construed to form part of this judgment. What I find quite perplexing is that my Advocate Weingart seems to blow both hot and cold, referring to the inquest record. On the one hand, he wants to have the inquest record deemed inadmissible due to the failure in not informing Mr. Stander of his rights to self-incrimination. On the other hand, he relies on the record insofar as Mr. Stander relied on self-defense, alternatively putative defense. Ogle v. Thompson, J.A. in Luwani, referring to R versus Ramakok, RAMAKOK 1919 TPD 305 at 308, where Caiphus J stated, and inverted commas, whenever a question is put to the witness which tends to incriminate him, I have always personally considered it my duty to warn the witness, especially an ignorant, and this is his words, not mine, capital N for native, witness, ... He continued at page 444G by adding, the above mentioned duty resting upon a judicial officer is no mere, and in inverted commas, technical rule, technical close inverted commas, as suggested by Wigmore, but, hyphen, as what was correctly noted by Caiphus J in the above cited passage, nor is it in my view an absolute duty, underline that, my underlining, in the sense that it is a non-observance will always and inevitably render a witness's incriminating statement inadmissible against him in the subsequent proceedings, close quotation. Firstly, even if Mr. Stander was not warned of his rights to self-incrimination, what he said at the inquest was not self-incriminating. On the contrary, it was an exculpatory defense which he proffered. Secondly, even if that evidence appears to be prima facie unlawful, we must pay credence to what Caiphus J stated in Keys versus Attorney General, Cape Provincial Division and another, 1996, Volume 2, SACR 113, in brackets double C, at paragraphs 13 and 14 of the judgment. I quote, in inverted commas, 13 in square brackets, close it, ... To be sure, a prominent feature of the tension is the universal and unceasing endeavor by international human rights bodies, enlightened legislatures, and courts to prevent or curtail excessive zeal by state agencies in the prevention, investigation, or prosecution of crime. But none of that means sympathy for the crime or its perpetrator, nor does it mean a predilection for technical niceties and ignominious legal stratagems. What the Constitution demands is that the accused be given a fair trial. Ultimately, as was held in Ferreira versus Levine, fairness is an issue which has to be decided upon the facts of each case, and the trial judge is the person best placed to take that decision, close quotation. 56. I am of the considered view that notwithstanding the inquest record being incomplete and the issues raised by accused number 3's legal representatives, what he testified at the inquest hearing was exculpatory. For that reason, the interest of justice therefore demands its acceptability as evidence in this trial. 57. I am alive to the erudite remarks of Cameron J.A., or rather the court, in the matter of S versus Tandwa and others, 2008, Volume 1, SACR 613 SCA, dealing with a fair trial, at paragraphs in square brackets 117, close square brackets, et sec. In that matter, the court dealt with the evidence that was obtained by assault and or torture. See particularly the remarks at paragraphs 118, where the court stated, open quotation, as we pointed out, ... central to this inquiry is the public interest. So far as the administration of justice is concerned, there must be a balance between, on the one hand, respect, open brackets, particularly by law enforcement agencies, close brackets, for the Bill of Rights, and, on the other, respect, open brackets, particularly by the man in the street, close brackets, for the judicial process. Overemphasis of the former would lead to acquittals of what would be perceived by the public as technicalities, whilst overemphasis of the latter would lead at best to the dilution of the Bill of Rights and adverse to its provisions being negated. Close quotation. 58. This begs the question whether his utterances at the inquest regarding how he acted in self-defense automatically implies its acceptance as evidence before me, bearing in mind that he did not testify in this matter where he is charged. At best, the court can accept that he said what he said at the inquest. However, it was not repeated under oath before me, and there was no evidence presented in this trial that he acted in self-defense. Furthermore, the magistrate who presided at the inquest did not make a finding in terms of Section 16, sub 2 of the Inquest Act. 59. It was submitted on behalf of accused number 3, who associated with the submissions made by Advocate Gissing on behalf of accused number 1, that the prosecution's case on common purpose changed from what was stated in the summary of substantial facts compared to their acceptance of the plea of guilty by Mr. Marais, where they accepted his statement that the common purpose was entered into at the Nyoka premises, whereas the summary of substantial facts clearly alluded to it taking place at the police station during the briefing. 60 in square brackets. Both counsel for accused number 1 and 3 submitted that the state's case in this regard changed. Whilst that may be true, the all-important question is whether the deviation is so material as to render the state's case impotent or non-existent. The deviation, in my view, seems to suggest that there were fewer people involved in the common purpose than the state initially anticipated. In other words, the net of perpetrators involved in the common purpose was scaled down, according to Mr. Marais' Section 112 statement. 61. Advocate Gissing submitted that Marais did not include accused number 1 in the common purpose to kill the deceased. Marais stated in his guilty plea that accused number 2 merely gave the instruction to him to Stander and to himself. Accused 1 was not present when the instruction was given, and at that stage accused 1 was on the premises, according to Mr. Gissing, at the front of the house and not in the courtyard where the instruction was given, which is at the back of the house. 62. In a nutshell, it was submitted that there was no evidence linking accused number 1 to the shooting of the deceased, and that the test at the end of the trial was that the prosecution had to prove its case against accused number 1 beyond reasonable doubt, which is a higher standard than when a discharge was sought at the end of the prosecution's case. Heading, failure to testify. 63. Before I analyze the arguments on common purpose submitted to the court, I would deal with the accused's right to remain silent during the trial and not to give evidence. 64. Section 35(3)(h) of the Constitution prescribes the right to remain silent. However, this right may have consequences for an accused person if he/she elects to remain silent in the face of a prima facie case which the prosecution has presented, and such person does not gainsay such evidence. 65. None of the 3 accused in this matter, as previously stated, gave evidence. The court would have to determine whether the state made out a prima facie case which needed some response from the accused. Having said that, it should not be understood, and I emphasize this, that the court places an onus on the accused to testify. 66. The Constitutional Court in the matter of Osman versus the Attorney General Transvaal, 1998, Volume 2, SACR 93cc, where Madala J. stated, and in quotations, open quotations, our legal system is an adversarial one. Once the prosecution produces evidence sufficient to establish a prima facie case, an accused who fails to produce evidence to rebut that case is at risk. The failure to testify does not relieve the prosecution of its duty to prove the guilt beyond reasonable doubt. An accused, however, always runs the risk that, absent any rebuttal, the prosecution's case may be sufficient to prove the elements of the offense. The fact that an accused has to make such an election is not a breach of the right to silence, full stop. If the right to silence were to be so interpreted, it would destroy the fundamental nature of our adversarial system of justice, close quotation. See also S versus Busak, 2001, Volume 1, SACR, CC, S versus Tandwa and others, Supra, S versus Molabatsi, 2024 in square brackets, ZAG, PPHC, 302 at paragraph 18, heading common purpose. 67. The doctrine of common purpose is a doctrine where individual perpetrators are held criminally responsible for the crime they did not physically perpetrate if they had a prior agreement or actively association with others to achieve it. In brackets, see page 20, Supra, where common purpose was referred to, close bracket. 68. This doctrine has received attention in the matter of S versus Tebus, spelled Thebus, 2003, Volume 2, SACR 319, where Moseneke J. found that it passed constitutional muster. 69. For the doctrine to apply, it was stated in S versus Magdezi and others, 1989, Volume 1, SACR 687, in brackets capital A, the following prerequisites must be met. At 705 alongside the letter J, hyphen to 706 alongside the letter B, namely, and in inverted commas, ... In the first place, they must have been present at the scene where the violence was committed. Secondly, he must have been aware of the assault if the inmates of room 12. Thirdly, he must have intended to make common cause with those who actually perpetrators of the assault. Fourthly, he must have manifested his sharing of the common purpose with the perpetrators of the assault by himself performing some act of association with the conduct of the others. Fifthly, he must have had the requisite mens rea, semicolon, in respect of the killing of the deceased, ... close quotation. 17 square brackets. The doctrine of common purpose was dealt with in the judgment of Machi versus S, 2021 ZASCA 106, at paragraphs 34 to paragraphs 40, where the Supreme Court of Appeal dealt with the issue of this doctrine as it applied in that matter. At paragraph 36, the court stated, open quotation, 36 in square brackets, in Devnat versus S, Makumi AJA explained the application of common purpose doctrine as follows. Single inverted comma, in the light of the facts of this case, it is important to note that the doctrine is espoused in S versus Magadezi, open brackets and close brackets, others, has been pronounced by the Constitutional Court to be constitutional. The requirement of active association is to curb a wide liability. Current jurisprudence premised on a proper application of Ngadezi, open brackets, and the word and, close brackets, other, makes it clear that, small Roman 1, there must be a close proximity, in fact, between the conduct considered to be active association and the result, semicolon, and, open round bracket, small Roman 2, close brackets, such active association must be significant and not limited participation removed from the actual execution of the crime, close quotation. (71) The prosecution in its summary of substantial facts alluded to the common purpose to kill Mr. Nyoka being discussed at the briefing at the police station. This would mean that all the police who were present at the briefing ought to have known that Mr. Nyoka was to be killed, as opposed to him being arrested. This would have involved all the police from the security branch, the riot squad, and the municipal police who were at the briefing. However, the state accepted that the plea of Mr. Marais alluded to earlier herein, where he stated that it was Mr. Engelbrecht, accused number 2, who gave the instructions immediately prior to getting into the room where the deceased was shot. On the plea of Mr. Marais, that Mr. Marais made, which the state accepted, accused number 1, Mr. Vandenberg, was not present when the instruction was given, and the requirement that he knew that Mr. Nyoka was to be executed was not established. Nor was there any evidence that he associated with the actions of the others. It was submitted that the court should infer that it was discussed at the briefing that the deceased was to be killed, because the operation was planned and the area was surrounded by police. Furthermore, the court should ask itself, why did they wear garments to cover their identities? All this suggested that the plan was not to arrest the deceased, but rather to kill him. 72. During the submissions before me regarding accused number 1's role in the operation, it is clear that he was at the scene at Lambeth Street. Notwithstanding his presence at the scene, the prosecution still bears the onus to show that he associated himself with the actions of the others. That is the requirement of Ngadezi. And that he was aware that Caiphus was to be shot. In other words, the mens rea. In this regard, I cannot make inferences of his knowledge regarding the other requirements referred to above. There is no evidence that accused number 1 associated himself with the actions of Marais, Engelbrecht and with the actions of Marais, Engelbrecht and Stander. CS versus Majosi, 1991, Volume 2, SACR 632. 3. Accused 1 did not testify. It is tried that no onus rests upon the accused to prove his innocence. The onus is referred to in paragraph 51.3, close bracket, rests on the state to prove its case. This begs an answer to the question whether there was a case for accused number 1 to answer, as suggested by Madala J. in the matter of Osman Supra. The issue was dealt with earlier in this judgment at paragraph 63 to 65, Supra. The case against accused number 2, 74. Mr. Moila submitted that accused number should be acquitted of the offense. The evidence against him is premised primarily on the evidence of Mr. Nyakane and the section 112 plea of Mr. Marais. He contended that Mr. Nyoka's pointing out of accused number 2 as the person who tortured him should not be accepted, as it was a doc identification. Mr. Nyakane did not mention this person in his statement that he could identify him as a suspect. He suggested that the witness was wrong when he stated that Mr. Engelbrecht is the person who wrote the words on the board as suggested in paragraphs 33 Supra. Mr. Nyakane spent a considerable period of time with accused number 2 in a room which was lit at the police station. He was tortured by accused number 2, according to him, and the latter also took him, that is Mr. Nyakane, to his house. They traveled in a car to his home, and he was also transported to the police station by accused number 2. In my view, Mr. Nyakane was with accused number 2 for a considerable period of time, and not for a fleeting moment or a short period of time. They were in close proximity to each other, and the room was sufficiently lit for him to see the person who he said was accused number 2. In this regard, I didn't enter this in the judgment, but the case law on this aspect is quite clear. The judgment which says you must ask a person questions as to the visibility, how far he was, what opportunity did he have to observe. I am satisfied that that test that was laid down, in that case dealing with identification, has been supremely met. 75. The issue of doc identification was dealt with in S versus Matwa, 2002, Volume 2, SACR, by Leach J. It is right that the issue of identification must always be viewed with caution. I've stated this earlier under basic principles of law. See the remarks at 356 alongside the letter small f to G, where the judge stated, and in inverted commas, no fixed rules can be laid down. In each and every case, the judicial officer must decide upon the weight, if any, is to be adopted to doc identification. Regard being had to all material circumstances, including those prevailing when the initial observation took place, as well as those under which the identification in court was made, ... I would simply mention, see also the remarks of State v. Saults and others, which deals with, whilst the court must take caution regarding evidence of identification, common sense must prevail. 76. One must bear in mind that accused number 2 did not testify. Although it was put to witnesses, the witness Nyakani, that he was mistaken, which the witness denied, accused 2 did not gainsay the occurrence which took place in the office, namely the writing on the board that it was lit. Mr. Nyakani's evidence does not assist the court directly with who was in the room when the deceased was shot. His evidence deals with what happened at the police station in a room and his assault/torture by the police who transported him to his home, who he identified as being accused number 2. Of importance is what this person wrote on the board in the room, which has a bearing regarding the shooting at Lambeth Street. 77. I am of the firm view that there is no plausible reason for him to have manufactured a narrative of what occurred in the room at the police station. On the evidence presented, he had enough time and opportunity to observe the identity of the person he was with in the room. In my view, the overwhelming probabilities support the proposition that he is not making a mistake regarding the identity of accused number 2, or that accused number 2 wrote what he wrote on the board as Mr. Nyaka testified. 78. On this score, Mr. Nyaka's evidence is strengthened by what Mr. Marais stated in his Section 112 statement, that it was accused 2 who gave the instructions to take out the deceased. That instruction, call it what you want to, is nothing other than an execution, an instruction to execute. If those words are construed to kill someone, then it was an execution, as was suggested by what was written on the board in the office by accused number 2. 80. As an aside, a lot has been made out of the case of S versus Daniel Notsuneng. Mr. Notsuneng was charged and he alleged that he received explosives from the deceased. He told the police who arrested him that he obtained the bag containing weapons and explosives from the deceased. The evidence presented in that trial was to determine the innocence and or guilt of Mr. Notsuneng in that matter. The finding of that court in that matter does not assist me in determining whether Mr. Nyoka was murdered or not by members of the SAP who raided his home on that fatal day. It merely explained why the police raided the premises as opposed to what their true purpose was. So, as I've explained to counsel when they were addressing me in the Notsunang case, the Notsunang case is water under the bridge. It is a mere red herring in this court having to make a finding as to the innocence or the guilt of the accused before me. And this court, therefore, distinguishes the trees from the forest. 82. In this regard, those who attended the deceased's room were best placed to explain what their intentions were and / or what happened there. However, they elected to remain silent in terms of section 35(3)(h) of the Bill of Rights, which was their choice to do so. The case against accused number 3, 83 in square brackets. Accused 3's counsel submitted that the inquest record should not be admissible as referred to, which I alluded to earlier. This aspect of the argument was dealt with earlier in this judgment, see paragraph 55. The evidence against him is the inquest record, which reflects that he testified and suggests that he acted in self-defense. There is also the section 112 statement of Mr. Maré, which indicated that he shot the deceased several times. It is now submitted that if the court finds that he did not act in self-defense, then he acted in putative defense. The suggestion that he acted in putative self-defense has manifested itself in the heads of arguments which were presented to this court. This, firstly, was not raised at the inquest, and it reared its head simply as a consequence of Mr. Maré's section 112 statement, wherein he stated that Maré, shot the deceased, who was not armed, nor did the deceased pose a threat to them. 84. Accused 3 did not testify, and consequently there is no evidence from his side explaining why he fired several shots at the deceased. In the absence of any explanation from him, how is the court to determine whether he acted reasonably in shooting the deceased as such, or that he acted in fear of his life? Is this court to simply infer that he acted reasonably? He, in my view, had to testify and raise his version. If he acted in self-defense, for the court to make a finding that a reasonable man in the circumstances that accused number 3 found himself in would have acted as he did. In this regard, see the cases dealing with self-defense, amongst others, S versus Patel, 1959, volume 3, essay 121, in brackets capital A, and S versus Motlaleni, 1976, volume 1, essay 403, in brackets capital A. 85. Mr. Weingaard also submitted that the prosecution failed to prove that the shots which accused number 3 fired caused the deceased's death. Without wanting to be critical to this submission, I will simply state that it is a desperate and ingenious submission because the prosecution is premised on the belief that the accused acted in a common purpose. And the accused set out on a political assassination. 86. Accused 3's reliance of putative self-defense again is a factless argument, as it failed to take the court into his confidence by telling the court what going on in his mind at the time when he fired those shots at the deceased. Heading case against accused number 1. Accused number 1's counsel submitted there was no evidence against his client and that the test at the end of the state's case that the prosecution had to prove its case beyond reasonable doubt as opposed to the stage where the discharge was sought. In this regard, the evidence was clear that he was not in the room when the deceased was shot. His counsel submitted that in terms of Maré's 112 statement at paragraph 6.16, 6.17, and 6.18, the following appears, and in inverted commas. 6.16. The deceased did not pose a threat when Stander and I fired the fatal shot. The deceased was shot with the intention to kill him. 6.17. Moments after Stander and I shot the deceased, Engelbrecht re-entered the room to inspect the deceased's body. 6.18. Van den Berg and Kilian followed Engelbrecht into the room. Kilian approached the body and confirmed that the deceased was dead. 6.19. ... close quotation. 88. Counsel for accused number 1 submitted. Accused number 1 was at the front of the house at the time that the 3 policemen were at the door of Caiphus, and there is no evidence that he heard the instructions which Mr. Engelbrecht, accused number 2, gave to Marais and to Mr. Stander. 89. It was submitted that accused number 1 did not testify at the inquest. In short, there is no evidence which ties him to the shooting of the deceased, or that he was aware that the deceased was going to be shot. For that reason, the requirements as set down in Ngedezi do not apply to him. By the same token, there is no evidence that he associated himself with the conduct of the others, as he was not aware of the intent by the others to kill the deceased. 90. In the circumstances and on the totality of the evidence presented, I make the following order. 90.1. The prosecution failed to establish or prove beyond reasonable doubt that accused number 1 associated himself with the actions of Mr. Marais, accused 2, and accused number 3 to kill the deceased. To this end, it also failed to prove that accused number 1 acted in a common purpose with the others to kill the deceased. Accordingly, accused number 1, Mr. van der Berg, is found not guilty on the charge of murder. 90.2. The evidence presented, in my view, clearly established that there was a common purpose between Marais, Engelbrecht, and Mr. Stander to kill Mr. Nyoka on the 24th of August 1987. 90.3. On the accepted evidence, the court finds that the assailants entered Mr. Nyoka's room not to effect an arrest, but to assassinate him. When the deceased was shot, he posed no threat to any of the policemen who entered the room. 90.4. Accused number 2 is found guilty of the crime of murder. The court finds that even though he did not shoot Mr. Nyoka, he gave the instruction that Mr. Nyoka should be killed. 90.5. Accused number 3, Mr. Stander, is convicted of murder. The court finds that he was one of the shooters who fired shots at the deceased, which caused the deceased's death. That is the court's findings.
That's a good point. That's a good position. Just want to end in the accused police to they have clean records. I have basically
Thank you.
My Lord, may we be excused?
Yes.
Thank you.
What's that? Let him, just sign him, you can. Right, Mr. Moila.
See, Bishop.
I'm sorry, I apologize.
I know you're telling this from the onset.
Yes, I apologize to you.
My Lord, we do confirm that there are cases no previous convictions and
Yes.
circumstances. We have even had an opportunity to discuss with the state what will be the consequences when the court comes to these decisions. But preliminary, we have prepared some affidavits in respect of the continuation of the matter for the bail whilst we're waiting for sentence, because I don't think that will proceed today. Hence, we've prepared an affidavit in support of the extension of bail as in terms of Section 58 of the Criminal Procedure Act.
Yes.
So that's where we stand now. We don't know what's the state's attitude to that effect as a
Right.
present. Yes. So that's where we stand. That's what we intend to do.
So what you in essence are saying that this matter will not proceed further and it would be postponed.
That's a probability. I
Yes.
just want to
Have
hear what
you-
my other colleagues.
Have you discussed a possible date?
We haven't at all, so hence I'm just waiting for my colleagues to indicate before this court what will be their suggestion, and maybe we can just follow and see what we can do.
All right, let's, Mr. Venkat, you want to say
My Lord,
something?
on behalf of accused number 3, it's also our instructions to apply for a postponement in the light of that we intend acquiring the services of inter alia, a psychologist as well as a probation officer, in order to furnish the court with the necessary reports in order for the court to make a determined decision pertaining to the sentence which needs to be imposed. So under the circumstances, we will also then ask for a postponement. We have also drafted affidavit pertaining to an application for bail. If the court will allow us to proceed today, maybe if I can maybe suggest that the matter maybe stand down, that we maybe have a discussion with the state and with your lordship in order to acquire an appropriate date to proceed with the sentencing process.
Let's hear what the state's attitude is regarding the issue of bail.
Can we be given just a few seconds to discuss amongst ourselves? It's not necessary to agenda.
Yes, switch off the machine, please.
Thank you so much for
Yes,
the
Mr. Mokgotsi.
attitude of the state now is that all two accused have been convicted of a very serious offense. And it is already on record that accused number 3, for instance, has been in and out of the country, that we really struggled to arrest number 3. And that because of the nature of the offense they have committed, both of them, that they be in custody. And they shouldn't be bailed at this stage.
So the state opposes the
I
application.
will oppose it.
Right.
We are, however, amenable to a postponement for sentence, but that the accused remain in custody.
Well, they want, the legal representatives want to move for an application. I can't stop them from doing so. Yes, Mr. Mosia, you may proceed.
Thank you.
Just a second.
Thank you, my lord, for the opportunity. Under the prevailing circumstances that the accused has now been found guilty, then the circumstances definitely, my lord, has changed, and that the onus definitely rests upon the accused, being accused number 2, to satisfy this court that there are exceptional circumstances in the interest of justice that permits his release on bail, because the standard has been raised high on the circumstances that he has been already found guilty. In light of that, we have prepared a written statement which has been sworn in on behalf of accused number 2 in anticipation of any outcome that would have taken place this morning. If the court permits me, may I read that into record?
Certainly.
Thank you. This is a sworn affidavit in support of the bail application. It reads as thus. The citation has been noted above. I, the undersigned, Abraham Hercules Engelbrecht, do hereby make oath and state that I am an adult-made Metropolitan Police official holding a rank of Lieutenant Colonel with the Ekurhuleni Metropolitan Municipality Police Department and residing at number 118 President Pretorius Road in Benoni, and have another home address at 45 Kipersol Crescent in Jeffreys Bay, Eastern Cape. The facts contained in this affidavit are within my personal knowledge, both true and correct, unless the contrary is indicated. I was standing trial before the above honorable court for one count of murder in that I acted in furtherance of common purpose when I committed the crime. I pleaded not guilty, and subsequently above honorable court found me guilty as such on the second day of December 2025. In terms of the Criminal Procedure Act 51 of 1977 as amended, the offence I am convicted on is regarded as Schedule 6 offence pursuant to the court having found me guilty. I was born on the 28th of June 1961 with identity number 610628 5024 088 and currently 64 years old and married to Madeleine Engelbrecht on the 26th of May 1981 and are blessed with 2 children, namely Charles Engelbrecht, a son aged 37 and at our care due to his health condition of a deep vein thrombosis, and Claudette Logenbeck, a daughter aged 41 who has 3 minor children undergoing a divorce. My wife's son, daughter, and her children are solely dependent on me as a breadwinner, and that her husband chases her away from their matrimonial home and does not support them. As a Metro Police official, I earn a gross monthly salary of 70,000 rand. I do not have any family outside the borders of the Republic of South Africa. I currently do not possess any valid passport or other travel document. I have not traveled outside the Republic of South Africa for the past 16 years when I was still an international air marshal by dropping the foreign nationals to their countries, and the last ones were in Malawi and Angola in 2008-2009. I do not have any previous convictions nor any pending criminal matter besides this one I have been convicted on. I do not have any protection orders, harassment, or any other court order against me. I intend to stay throughout my remaining life within the borders of South Africa, more particularly in my home in the Eastern Cape when I retire. I was diagnosed with severe health condition and had suffered 2 strokes and loss of 40% on both sides of my brain, totaling 80% brain loss. My consulting specialist doctor had been treating me since 2019 and had diagnosed me with a dilated cardiomyopathy and deteriorating heart function. He said I now present for an extended period with NYHA class 3 heart failure and that my heart function is less than 30%. I am permanently on medication including blood thinners and on constant pain for 24 hours with massive pulmonary embolysis and loss of full usage of a right lung. If the above honorable court accepts my personal circumstances as those required by law in the interest of justice, and that there are exceptional circumstances that permits my release on bail, I shall be able to raise the sum of between 2,000 rand and 5,000 rand. My Lord, without referring to the affidavit, I'll just continue. We've prepared a separate bundle in respect of his health diagnosis and condition that will be submitted together with the affidavit that we've prepared. At paragraph 10, the above honorable court may impose any conditions that it deems fit, taking into consideration my personal circumstances and those of the society at large, as represented by the state, and I will abide by the following. I will not endanger the safety of the public or any particular person, nor will I commit any offense. As a Metro Police official, I am tasked to oversee compliance with bylaws, protect and serve the community at large within the entire Ekurhuleni region. At no stage will I act contrary to my oath of protecting and safeguarding the residents of Ekurhuleni. I will not attempt to evade the finalization of my sentence and will attend to court on the date so directed by the Honorable Court. As I have alluded above, that I am still employed by the City of Ekurhuleni as a Metro Police officer and have no intention to leave or abscond from my post unless I am released by my employer. I will not attempt to influence or intimidate any witnesses, though not necessary now, or to conceal or destroy evidence because the Honorable Court has already ruled on the merits of the matter. I will not undermine or jeopardize the objectives of or the proper functioning of the criminal justice system, including the bail system. I will be able to report to the closest police station if the Honorable Court so directs. I am advised by my legal representative, of which advice I take, that I am now convicted of a serious criminal offense of murder, which carries a direct term of imprisonment. I wish to state that I will abide by any conditions imposed on myself and that I shall commit myself to both police or prison officials should I be sentenced accordingly. I wish to further state and submit that the state will not be prejudiced at all should I be released on bail, and moreover, I have a valid fixed residential address, home, and employment address within the jurisdiction of the above Honorable Court. The very same affidavit has been duly signed by the accused and has been commissioned accordingly before this court on the 2nd of December 2025. That will be accused number 1's request or application as in terms of accused number 2 as in terms of section 58 of the Procedure Act 51 of 1977. And I'll couple that with the report that we've presented.
Yes, thank you.
May I beg leave to hand
Mr. Engelbrecht, do you confirm the contents of the affidavit that was read out?
Correct, my lord.
Thank you. Is there any further evidence you wish to leave?
There's no other way
That is your
evidence
case.
that we intend. That's the accused number 2's case.
Thank you. Yes, Mr. Nyoka.
Thank you, my lord. Pertaining to accused number 3, in amplification of the application for bail, we've also drafted an affidavit. Will then be believed to read same into the record.
Yes, please go ahead.
Can I just hand to your lordship the signed original one from the accused number 3? I've also handed a copy to my learned colleague for the state.
Thank you.
Affidavit in support of application for bail, I, the undersigned Peter Egbert Stander, hereby state under oath as follows. I'm an adult unemployed man residing at 1587 Cruden Bay Street, Copperleaf Golf Estate, Centurion. I repose to this affidavit in support of my application to be released on bail pending my sentencing on a date to be decided by this honourable court. Facts stated herein are true and correct and fall within my personal knowledge unless otherwise stated. My legal representatives will address this honourable court at the hearing of my application on the schedule to be applied to my bail application. Background, my mental health. Before I deal with my personal circumstances and factors which I will respectfully submit support of finding that the interest of justice permit my release on bail, I wish to summarize what I believe to be the relevant background factors to my application. At the time of my arrest on 4th of April 2024, I was employed by Sallyport Global Services, a division of Equity International, as a protection officer. I commenced employment with Sallyport in October 2015 and was stationed in Iraq. My day-to-day tasks were primarily to ensure the safety and security of foreigners working in Iraq. My income at the time I was placed on medical leave in April 2024 was $10,526 per month. During my time in Iraq, I, together with my fellow employees, was subjected to many attacks on a hostile warfare scale. These attacks included rocket-propelled explosives. Unbeknownst to me at the time, and as a result of the severe and traumatic conditions under which I was employed, I was already suffering from what I've been advised as post-traumatic stress syndrome, although the symptoms thereof had not yet fully manifested. Whilst I employed, I would return to South Africa every 3 months or so for 2 weeks of rest and recuperation. I would spend the time with my life partner as referred to under my personal circumstances hereunder. On the 4th of April 2024, I returned to South Africa for such a visit. Upon my arrival at OR Tambo Airport, I was arrested by Lieutenant Colonel Beekman. I was thereafter taken to the Benoni Regional Court where, and after a formal bail application, I was released on warning. Lieutenant Colonel Beekman did not oppose my application on condition that I provided him with my passport. Lieutenant Colonel Beekman advised the court that he did not oppose my application on the instructions of the state. My matter was then transferred to the High Court in Benoni for trial to commence this scarcely a few weeks later. The period I was given to prepare was far too short for me to properly prepare for trial, and my legal representatives were accordingly compelled to request a postponement. As I would not be able to continue with my employment if I was not permitted to leave South Africa, I brought an application for the return of my passport in exchange for the payment of an amount of bail. My application was successful, with the court ordering that my passport be returned on condition that I pay bail in the amount of 300,000 rand. After paying bail of 300,000 rand, my passport was returned to me. Agreed by the court's decision, as aforesaid, the state gave notice of its intention to appeal against this decision. Following my arrest, my mental status deteriorated dramatically. Amongst the most Notable symptoms I experienced was a loss of memory. After reporting my symptoms to Dr. Deploy, our house doctor, Dr. Deploy, referred me to a psychiatrist, Dr. Kariuki. Dr. Kariuki had me admitted to the Akeso Mental Health Institute in Pretoria on the 2nd of May 2024. With the inception of my court appearances on the 15th of May 2024, as referred to here under, I remained at Akeso until my discharge on the 22nd of May 2025. As a result of my condition, my employer placed me on medical leave without pay. As it was clear to me that I would no longer be able to fulfill my duties and obligations towards my employer in accordance with the terms of my contract of employment, and my road to recovery was likely to be a very long one, and I had been placed on medical leave without pay. I voluntarily surrendered my passport to the state without the need for the state to proceed with its appeal. On the 16th of May 2024, and at the High Court held in Benoni, the fact of the return of my passport to the state was recorded, and the court ordered that the bail I had paid be returned to me. I am now treated by Frans van Staden, a psychologist, and Dr. Kariuki, a psychiatrist, for what I understand is in layman's terms referred to as PTSD. It is as a result of the aforesaid treatment and chronic medication that has been prescribed that I'm able to cope with my symptoms on a daily basis, my physical health. On the 29th of January 2024, and because my life partner and I thought I might be having a heart attack, we went to the Braslow clinic where I was admitted on the same day. After a thorough examination, I was advised that my gallbladder had to be urgently be removed, and so I underwent an operation for this purpose on the 31st of January 2025. I remained in hospital thereafter until the 13th of February 2025, when I was discharged. I subsequently developed septicemia and was admitted back to the hospital on the 6th of March 2025. When an aggressive treatment of antibiotics did not help, I was operated on again on the 26th of March 2025. I was advised that my intestines had to be cleaned up, and I was thereafter discharged on the 4th of April 2025. I was advised to remain in bed for as long as possible and until I had fully recovered. Notwithstanding the aforesaid advice, and in attempt to prevent any inconvenience to this court, the state and my fellow accused, I nevertheless attended court to continue with the trial in May 2025.
Yes.
That decision almost cost my life. Whilst at court on the 14th of May 2025, my leg became sore and swollen. After undergoing a scan, Dr. Deploy informed me that the scan revealed that I had life-threatening blood loss and that I had to be operated on urgently. On the night of 15 May 2025, Dr. Philip Elof operated on me to remove the blood loss. I was discharged a week later. At my post-operation evaluation a month later, Dr. Elof expressed concerns about my condition and apparent lack of proper recovery and referred me to Dr. de Jong at the Little Company of Mary Hospital in Pretoria. Dr. de Jong advised me that I had a hernia that would become life-threatening if not dealt with as a priority. In an attempt not to inconvenience the court, the state, and my fellow accused, I did what I could to arrange for the operation to be held on a date that would not interfere with the court proceedings. Dr. de Jong conducted the operation on me at the Groenkloof Mediclinic on the 14th of October 2025. I was discharged on the 17th of October 2025. With the exception of the bulge referred to here under, the operation appears for the most part to have been a success. Upon consulting with Dr. de Jong at my post-operation follow-up, I complained to him about a small bulge in my abdomen in the vicinity of the area in which the operation had been conducted. The bulge manifested post-operation and appears to have been caused by the operation. The bulge is very sensitive and very painful, and I am now on chronic medication to deal with the pain as a result. Dr. de Jong has informed me that the bulge does not appear to be immediately life-threatening, but has advised that I should have it attended to as soon as I am able to undergo another operation. He has proposed for this to be done towards the end of January or at the beginning of February 2026. In the interim, I have been advised to rest as much as possible. Claim against my employer. After being advised that I had a significant claim against my employer for my so-called PTSD, I instructed attorneys in America to assist me in prosecuting my claim. The attorneys acting on my behalf in this regard are Barnett, Lerner, Carson, Frankel, and Castro, as represented by Anna M. Castro. They are based in Fort Fort Lauderdale. The case and or reference numbers allocated to my claim are OALJN02 2025 LVA 02970 and OWCPN 002554203. I'm further advised that my claim is likely to be finalized in the first half of 2026, and I may be required to submit myself to further test and or examinations as may be required by my attorneys or my formal employer, and my attorneys are confident that I should succeed with a claim to the value of approximately $250,000. In anticipate having to play an active role in the finalization of this claim over the next few months. If I fail to submit myself to further examinations if required, or fail to participate in the hearing of that matter, then I'm advised that my claim may very likely be dismissed. My personal circumstances. I may summarize my personal circumstances as follows. I'm 62 years old. I'm not married, but consider my life partner, Linda Kluter, to be my common law wife. Linda, we have lived together as such since 2007. I have a daughter who lives in America. We have unfortunately become estranged over the years, and I have not had any regular contact with her. I last saw my daughter more than 5 years ago. I'm currently unemployed for the reasons as set out in paragraph 4.1.19 above. I currently have no source of income. Lydia and I are living off the money Linda was able to save over the years from the income I earned whilst employed by Sally Port. My legal and medical fees have taken a toll, and these savings, and currently we have approximately 400,000 rand left. Linda is 50 years old. She is unemployed. Linda did not have to work in the past as my income was more than adequate to cater for her financial needs. Since my return in the deterioration of my medical conditions, she has mostly looked after me. I attach here to as Annex A a summary of our joint expenses, for which is evident that our approximately monthly expenses are 61,678 rand. The only assets of any real value that I own are the following: the immovable property situated at 1587 Prudent Bay Street, Copperleaf Golf Estate. I attach here to a copy of a deed cert relevant to this property as Annex B. I estimate the value of the property to be 4.5 million rand. There's a bond registered over this property with APSA. I attach here to a copy of the latest bond statement in this regard as Annex C. Linda and I have lived in this property for the past 12 years. As is evident from Annex C, the outstanding bond register over the property is approximately 944,000 rand. An X3 BMW, I estimate the value of this vehicle to be approximately 850,000 rand. The vehicle is financed through BMW Finance. I attach here to a copy of the latest finance statement in respect of the BMW as Annex D. Household furniture and contents. I estimate the value of my household furniture and contents to be approximately 350,000 rand. I'm a South African citizen and was born in Springs on the 15th of March 1963. I matriculated from the Huguenot High School in Springs in 1981. I was called up for military service in 1982 and was then drafted to the police force. I left the police force in 1988 and joined the South African Army. I left the South African Army in 2007 and was thereafter employed in the private security industry until I took up employment with Sally Port in 2015. Except for my daughter in America, I do not have any friends or family outside of South Africa. If my life had gone to plan, then I intended retiring to my immovable property as Copperleaf. Factors relevant to the deciding my bail application, I'm advised, which advise accept that the following factors will be considered in deciding whether or not it is in the interest of justice that I be released on bail. Whether or not there is a likelihood that if I were to be released, I would endanger the safety of the public or any specific person. In this regard, I submit that there is no reason to believe that I pose any danger to the public or any specific person. I submit specifically in this regard that I have not threatened any persons with any form of violence, and I do not hold any grudges against any persons. And there is no evidence demonstrating that I have tendency to commit crimes, as is clear from the fact that I have no previous convictions. Whether or not there is a likelihood that I may attempt to flee, in this regard I wish to emphasize the following. Neither the state nor Lieutenant Colonel Beekman had any objection to my initial release on the same day as my arrest. and although my passport was subsequently returned to me and I had ample opportunity to flee if I wanted to, I surrendered my passport to the state out of my own free will when it became clear that I no longer required the passport. I submit further that it should be clear that I have strong ties to my life partner and the Copperleaf area. If I were to flee, I will have to give up my relationship with Linda and would lose my immovable and other property. If I were to be sentenced to a period of imprisonment, I would at least have the prospects of returning to Linda and keeping my immovable property and living out my life at Copperleaf once my sentence has been served. Without a passport, I have no means of leaving South Africa. In any event, I have nowhere to go and certainly do not have the financial means to survive for very long in a foreign country. Excuse me. Whether or not there is a likelihood that I would influence witnesses, as I have already been convicted, I submit that this factor does not play as a significant role as it would prior to my conviction. In any event, I submit that neither the state nor Lieutenant Colonel Beekman have any such concerns, as is evident from the fact that my initial release on warning was not opposed. Whether or not there is a likelihood that I would undermine the proper functioning of the criminal justice system, I submit that there is no likelihood that I would undermine the proper functioning of the criminal justice system. I submit further that the fact that I did all I could to attend court, notwithstanding my medical condition, corroborates my submission that there is no such likelihood. Where in exceptional circumstances there is a likelihood that my release would disturb the public order, without conceding that the aforesaid exceptional circumstances as contemplated exist, I acknowledge that this case has received a lot of public attention. It has been broadcasted and published on various public media platforms. The same applies to the trial of Mr. Johan Maree, who pleaded guilty. Although the case has received a lot of publicity, it has throughout been my impression that the public, including the family of the deceased, have behaved themselves with the utmost respect towards the legal system and the trial process. Sorry, they have further respected the court's decision to initially release me on warning. I submit that there is no reason to believe that my release on bail pending my sentencing will in any way undermine the public's respect for and faith in our criminal justice system. It's a matter of record that Mr. Maree was released after his conviction and pending his sentencing. To the best of my knowledge, there was no public outcry or protest against Mr. Maree's aforesaid release. I submit that the following additional factors, which I submit are exceptional in their nature and specifically when considered cumulatively justify a finding that my release on bail pending my sentencing is in the interest of justice. My physical mental health. With reference to my mental and physical health, as referred to in paragraph 4 above, I will have to consult with various experts with a view to providing a report or reports to this honourable court relevant to what an appropriate sentence in this matter might be. My detention pending my sentencing would severely handicap my ability to have such a reports drafted and finalized. Operation in January, February. If I were to be detained pending my sentencing, I would not be able to undergo the operation referred to in paragraph 4.2.19 above. This would entail that I would continue to suffer the discomfort and severe pain caused by the bulge indefinitely. Claim against my erstwhile employer. My detention prior to my claim being finalized would potentially severely jeopardize the potential success of my claim. This is particularly so if I were to be called upon to submit myself to further examinations or to participate in the hearing of the matter. I further request the Honourable Court to consider my previous bona fide actions, including my undisputed cooperation with the investigating team from the inception of this matter. And I attended all court proceedings with the exception of the instances where my poor health prevented me from doing so. I wish to respectfully place particular emphasis on the fact that Mr. Johan Maree was released pending his sentencing procedure. It will be argued on my behalf that there appears to be no good reason why I should be treated any differently, and particularly so as I will have to consult with various experts to provide this court with a proper pre-sentencing report. If I am released on bail, I undertake to further comply with any and all conditions attached to my release on bail and attend any further court proceedings. I am able to pay bail in the amount of 20,000 rand, which I respectfully believe is more than adequate under the circumstances. I accordingly respectfully request the Honourable Court to order that I be released on bail in the amount of 20,000 rand and further subject to such conditions as this Honourable Court may direct. In this regard, I undertake to report to the nearest police station on a regular basis, and as may be directed by this court if the court believes to such a condition is necessary. My Lord, the said affidavit is then duly dated today's date, signed by the applicant or accused number 1 in this matter. I then beg leave that it be handed to the court and forms part and parcel of the evidential material before your Lordship.
Mr. Sunday, you confirm the contents of the affidavit? Thank you.
Thank you, my Lord. We do not intend leaving any further evidence, so that will then be the application for accused number 1 pending, with the reservation of what the state is going to accuse as the court pleases.
You don't want to argue? Mr. Do you want to argue? I know you've handed up the affidavit.
Yes.
Is there anything you want to say?
My Lord, in addition, just for argument, I wish to state before this court that at the time of the proceedings of this matter, accused number 2 in this matter has been on warning ever since he was indicted on this case, and have submitted himself to attend the hearings on all the occasions. At no stage did he absent himself, which shows that the respect that he has for the above honorable court. And further to that is that the accused, as he stands now, is that if he is not able to be released on bail, not only the accused will suffer the consequences of being detained in custody, that even his support structure, being the family that are solely dependent on him, will suffer most, and will cause much more prejudice on his behalf. The only thing that I wish to add in respect of the application itself is what was indicated in the matter of State versus Dlamini, the constitutional court case that is well known, that was combined with the other cases of the skitex and other stuff, that the court did make mention of the facts that the provision of section 64A to E are those requirements that the accused or any other applicant should meet in an attempt to be released on bail. I think, to quote the court's verbatim, what it says in that respect is that this section does not say that the exceptional circumstances have to be over and above and different from the factors in section 64 to 60, subsection 4 to 9. The court must see to it that the accused is given a reasonable opportunity to indicate exceptional circumstances, and to that end, the accused must be adequately informed about what the case against him or he is. In this case, the case has already been presided
But
over.
that case deals with bail preceding
Preceding
a
that
verdict
appeal.
of guilty.
Yes, I'm
So
referring
the presumption of innocence applies in
It does.
Dlamini, Skitekat and others. Now the presumption of innocence
that's for
doesn't weigh in favor of the appellant or the applicant. So that is an important factor. This, the scene has changed dramatically.
It has indeed, my lord.
And, the authority for bail pending appeal is not Dlamini Skitekat. It's a judgment which I gave, where I was taken on appeal to the Supreme Court of Appeal, and the Supreme Court of Appeal found I was right. It's a matter of Beerke, and it was given by no lesser judge than Justice Meyer at that stage.
Yes, my lord.
What are the exceptional circumstances here?
Under the circumstances that prevails for accused number 2 in this matter is his health condition.
Yes, I take note of that. It is health condition.
His health condition and
But-
the fact that he has been attending court.
No, but he's been attending court is fair enough. But as I say, the scene has changed dramatically.
It has. The standard has been raised.
Not just the standard, it's like almost there's been a change in the climate from a bright day to now darkness.
Certainly.
He's been convicted of murder. And if one refers, if I think off my head, I haven't thought about the sentence yet, but if I just think off my head to a case of State versus Ingram, it's a 1995 decision pre the Criminal Law Amendment Act, where the judge then said that everybody knows that the likely sentence for murder, not that it's cast in stone, the likely sentence for murder is imprisonment.
Yes, as we mentioned in our
Yes, in
opinion.
that judgment. It's an AD decision.
Yes, indeed.
Now, on the one hand, prior, you're correct when you say he was out on bail. I have no qualms with that. But now he's been convicted, and he now knows that the sword of Damocles hangs over his head.
Definitely, my lord. The only reason that we come before
And
this
you're
court-
asking now for 2,000 to 5,000 rand bail. I mean, would that be enough incentive?
My lord, it's taking into consideration his own circumstances.
Yes.
It's unlike any other applicant that will come before court.
Fair
Who
enough.
can afford, and he still owns a property in the Eastern Cape and stays in another property in the Gauteng region because he's employed around the area. The other issue that I wish to raise with the court, it just slipped my mind now. It's a question of, I think I'll come back to it as we progress. My lord, the other aspect that the court I need the court to consider is that during the process of preparing for sentencing in this matter, the accused still has to undergo various consultations and various consultations. And moreover, in his case, because his instructions are subject to the state attorney itself, we still need to converse on how far will they take his matter further. So definitely, if the accused remains incarcerated in prison, it will make it difficult to exhaust those consultations in preparation for his sentence.
Yes, I hear what you say. I've been in practice for many years, almost for 30 years. So I know the problem with this. And, I've also had to go in many matters. I don't want to throw names around here, but I did many, many prominent cases where my clients were refused bail and I had to go and consult.
Yes.
At a maximum in Pretoria, I had to go to Sun City. I know it's inconvenient, and I know that it's, speaking for myself, one of the worst things to have done is to go to the prison to go and consult. You phone, you make an appointment for 10 o'clock, they bring the chap at 12 o'clock. I understand that. But that is the system.
It is.
So whatever, that's how it is. So is that a reason that you're saying, because it's going to be inconvenient, the inconvenience overrides everything else, he must be given bail? I mean, what about public perception?
As my colleague has
At the moment we sit here and you watch television, every channel you put on is about the justice system. I'm so sick of it. Every channel you put on, whichever one, it's the same thing. And people are complaining about bail, and you've heard it. I don't live in a cocoon.
Yes, I definitely know that our justice system has turned into a movie now.
One of the big grievances has been people have been committing serious offences, and they keep getting bail.
Definitely.
Please, will the public, do you people want me to clear the court? Do you want me to clear the court? Right. So please, this is not Orlando Stadium where Chiefs and Pirates are playing. This is very serious what's happening here. If you want to go and comment, please go in the outside. There's ample space to go and make noise outside. So what do you say about all that, Mr. Nui?
No, I've already noted what the court has said, and I just want to submit that we stick by what is contained in our affidavit. And
Thank
that
you. You have nothing
the
else further to add.
applicant stands as a candidate to be released.
I
or
just
extended.
thought I'll give you an opportunity if you want to add anything.
No, that's fine.
Mr. Benson.
Thank you, my lord. May I just get an indication, am I now to address your lordship on the merits of the application before the state is going to...
Well, they are opposing it, so they're going to say you shouldn't. But do you want them to argue before you? I thought I'd give you...
My lord, I do not know if they intend calling any witnesses or reading any evidence before I address your lordship. Surely we have...
Are you going to need any evidence, Mr. Mafatsi?
My lord, there are just two things to clarify or to put on record. Firstly, that my learned colleagues here do not state for how long they want this postponement. What is going to happen tomorrow? They don't state it. That's the first thing. The second thing is...
There's no way they'll be able to postpone till tomorrow because they say they're going to ask for reports. And we know that the soonest that you can get a report is 6 weeks. And that too is, experience has told me that even in 6 weeks they don't get it. Sometimes in the other matter, if you recall, Mr. Mares met
The second thing, may I proceed?
yeah.
The second thing is they kept their cards very close to their chest. They never indicated to us that they are going to apply for bail. They never indicated to us that they have already.
Well, it seems like they knew what the outcome was going to be, because these affidavits are 12, 15 pages and they're all written, you know, typed out. So, you know, it's almost, but whatever, it doesn't matter. So they knew.
My Lord, we.
You know the English saying, to be prepared is to be forearmed, to be forewarned is to be forearmed. They came forearmed, you see.
My Lord, we were not favored with the documents they just write into the record which they handed in.
Well, in essence, it's a simple argument here. The argument is twofold. This trial went on, we came to court on every occasion. That is the argument. And the second argument is the health reason, that they have to undergo certain health procedures, and if they're incarcerated, they won't be able to get that. That is a simple, it's nothing complex. That is in essence the argument. But whilst you're on your feet, I'll throw a curveball. And the curveball is that accused number 3, who's out on 300,000 rand bail, is now asking for a reduction of to 20,000.
Which is a joke, my Lord.
Well, you know, that is why I'm saying I'll throw a curveball. In other words, he was out on 300,000 rand bail. Now that he's convicted of murder, well, let's reduce this. I mean, you know, it's not like maybe they think the court doesn't think.
My Lord, the accused are just not prepared to take this court into their own confidence. They're actually playing games.
But that is not the test.
That is not a test, my Lord. But can I ask the court just for an adjournment of 10 minutes, so that, or 30 rather, so that I can consult with my colleagues about these issues? Because like I'm saying, we were taken by surprise. Now, can we be given just 30 minutes to just...
But why is it whenever I come, I must give you people court time to discuss things? I mean, really, that is why these cases don't get done, because court time is used for consultations. I would be able to make you know, after you address, I'll be able to give a judgment immediately, because I know the case law and I know what I'm supposed to do.
And
the facts are simple. They are saying, no, this accused number 3 has got all these major problems, he's got health problems, and if he goes into jail, he won't be able to go for he's going to go in January for some operation, and so on and so forth.
Just a moment, my Lord. Now that I can't, I'm not able to. Can I just consult with you?
Yes, please do.
Because we thought that
Please
we
do.
would ask for an adjournment of about 30 minutes so that we can consult among us. Because we are not even favored with these documents. For instance, number 2, Mr. Musiwa, has not even given us the document. We don't know what does it look like. Number 3 just gave us a document right now. We haven't even read it. But as it pleases the court, can I just get a few minutes to consult?
Switch off the machine when you can speak for as long as you like. Yes, switch off, please. ready to proceed?
Yes, my lord, we could not get an adjournment to discuss what we wanted to discuss, but we will do whatever we can, which is within our means. Like, we just want to say once again that we were just taken by surprise. We were not doing the documents and so on. But be that as it may, we have discussed this issue.
Yes.
And the conclusion is that, seeing what is happening now, the conclusion is that they may, of course, they may be granted bail, but not 2,000 and 1,000 that they are saying. At least an amount of 100,000 each, because the circumstances have changed. They have been found guilty of offense. And my lord, I'm also worried about creating law for separate people. When it's other people, we may say, no, there's no bail. When it comes to others, no, then there must be given bail. We should be aware of being consistent in whatever we are doing. But be that as it may, we concede to a bail of 100,000 on the following conditions. The first condition is that they must report to their respective police stations, which is Davidson, the Benoni police station. They must report there twice a week, which could be on a Monday and a Friday. That's the first. That should be the first condition, my lord. We also request the court to come up with a second condition, which is that they should not leave the province of Gauteng without informing the investigating officer. A third condition, my lord, should be that they should, those who are having their passports and so on, should surrender their passport, and whoever has handed in his passport should not go and apply for another passport. That's the third condition. And the fourth condition, my lord, we saying, because accused number 2 is still employed almost where he may be with EMPD, but the fact of the matter is that he's within the Benoni Metro together with Gugu. The third condition is that he should stop approaching Gugu on any other thing. He has testified. But what is about his beard or anything else, he should not approach Gugu on any other thing. That would be our fourth condition. Thank you.
Now, what is the test? Because you accede, you've conceded rather, that you have no objections to them granting bail. Am I bound by that?
You're not. You're definitely not bound. The law says it's for the court to determine whether...
In fact, the bail, the custom is that in murder cases, when a person is convicted, immediately the bail comes to an end.
That's true.
And then the court is now in a different situation. It falls squarely within the court's
discretion.
the court's ambit. Is that not, or am I wrong?
You are 100% correct, my lord. Actually, the court, I should have said, I should have placed it on the court that we have reached a stage where the court can exercise its judicial discretion.
I simply, as a matter of applying the Audi, gave you people an opportunity and not just make up my mind. But now that I've heard all, the facts and the dust is settled.
For instance, my lord, if I may say this, that if you look at their application, it's based on ill health. It's also based on the fact that they can't leave their families alone, and that they have children to maintain. They are not even telling us whether those children are minors or not.
No, they've said so. They said.
And there are so
In fact, in the case of accused number 3, they're both adults. One is 41 and one is 37 years old.
But there are so many people who are in custody who have committed murder, who have left their children behind. There are so many people who were maintaining their families.
I know this doesn't have any relevance to a bail application, but you're aware of the remarks of Justice Sachs in the Constitutional Court matter, which talks about primary caregivers on
Yes,
sentence.
I was just about to say that. Is it R versus M?
That's the judgment I'm referring to.
M is quite clear on
You can't shield behind your children.
And that is why I said today they are not even telling us whether they are minors or, because I was simply getting there that they are not telling us that they are primary caregivers. In any event, the state is offering SASA is offering grants for children, and I don't. In any event,
No, but this doesn't apply here because you are 41 years and 57 years
They are
old.
adults. They are adults. Why should they be regarded as children? And that is insofar as the family is concerned. But if I may quickly touch on the issue of maintaining or waking and so on and so on. So many people are in custody who were working and who are incarcerated and who have left their jobs like that. But on the issue of also suing the state, we are also that I must be outside because I'm suing the state. I don't know what is that taking us to. Because firstly, we don't know when did he decide to issue summons. When did he become aware that he's not well because of what happened before? Is it because now he's appearing before this court that he's coming up with this issue of suing the state or not? And even whether he's in custody or not, he can still be consulted while he's in custody. I don't see how it can stop him or any form of consultation, because consultation.
So are you now arguing that that the state's arguing now he shouldn't get bail?
No.
Because that's where the direction you're heading. You concede.
No, I'm just placing all these facts before.
No, those facts are before me.
Yeah, so
I've heard them, and you know what? It's like it's simmering in my head, the facts.
As it pleases the court, then I'll leave it at that. I'll take it back.
Right. What, you want to say anything, Mr. Venga?
Thank you, my lord. My lord, just pertaining to the aspect of the amount of bail, your lordship, in the affidavit, it's made clear that what transpired initially is that the accused was remitted on warning. Then he then applied for his passport back, and under those circumstances, an amount of 300,000 rand was set for bail. He, however, that specific order was not continued with, and the monies were then, the passport was handed. The passport up to today is still in the possession of the state, and the monies was then given back to the accused. So as we stand today, before he was convicted, he was actually warned to appear in court. My lord, then pertaining to what the court must now apply, it's my humble submission that it's quite clearly that this matter now resorts under the provisions of Schedule 6. So the court has to find exceptional circumstances in order to make a finding that it is indeed in the interest of justice for the applicant to be remitted on bail. Now, my lord, it is my humble submission, if one only look at the facts of this matter, question needs to be answered, is this not in itself an exceptional case that your lordship has been dealing with? I am not aware of any other matters pertaining to the facts which your lordship has heard, pertaining to the fact that this offence was committed 37 years ago, and under the circumstances the state has now decided to prosecute, and the accused has now been found guilty. I submit, my lord, if you only look at the facts of this matter, it is clearly not a matter which the court has dealt with. I do not know, my lord, but I submit the court has not dealt with such a type of matter in your lordship's career. Furthermore, I submit that if one look at the circumstances in itself, it must be said that it is exceptional, especially due to the fact that the accused number one, Mr. Mare, who pleaded guilty, my lord, he pleaded guilty, and notwithstanding that, the court in that matter, and once again, I duly appreciate the fact that each matter needs to be determined on its own facts. However, my lord, it is so that in many other matters, where an accused is convicted, the court will then, the bail is then cancelled, and the accused is then postponed in custody. However, my lord, it is my submission in this specific matter, it is so that accused number one, Mr. Mare, who pleaded guilty to the actual murder and who actually implicated accused number 2 and 3 in this matter, was granted bail after he had pleaded guilty, and we all know that he actually attended the sentence proceedings where he was sentenced.
Mr. Venga, you're not arguing for Mr. Mare, and secondly, the facts differ.
Yes.
Mr. Mare and the state were trying to enter into some type of entente cordial, which you're not telling me about, which I know that they were, because they were hoping that he would become a 204 witness.
Yes, my lord.
So Mr. Mare was playing, sort of games with them. So they were hoping that, so don't address me on Mr. Mare, the facts differ. Mr. Mare pleaded guilty, your clients didn't plead guilty.
My lord.
So, let's compare apples with apples.
My lord,
not
that
apples
is so.
with watermelons.
That is so, my lord, but what I'm asking the court to do is to look at all the exceptional circumstances, and one of the factors which the court must take into consideration pertaining to all the factors that we've mentioned in the statement, my Lord, is the fact that Marais was indeed granted bail. My Lord, furthermore, I submit that the facts of this matter in itself must be exceptional under these circumstances.
So in other words, are you telling me I must give them bail and my hands are tied even when it comes to sentence is exceptional?
No,
you know,
my Lord.
I have a discretion here.
My Lord,
Or am I wrong?
No, my Lord, I'm not saying that the court does not have
Right.
a
Now, what is the
discretion.
exception?
If the court will give me an opportunity to address the court, my Lord.
You keep talking about Mr. Marais. I'm not
No, my
interested
Lord,
in Mr. Marais.
I'm dealt with Mr. Marais. If the court will give me an opportunity, all that I'm asking the court is to apply the provisions of, to apply the law pertaining to the fact that this is a Schedule 6 bail application. So the court must look at all the circumstances in order to determine whether or not there are exceptional circumstances.
And on who is the onus?
My Lord, on the applicant, but that is what the applicant has done. Throughout the affidavit, all the factors that has been placed before the court. My Lord, so we will ask the court to make a finding that indeed all the factors constitute exceptional circumstances.
Yes.
My Lord, then furthermore, it is my humble submission, and the court has referred inter alia to the matter of Ingram. There's also other matters, Flanagan, which the court is also quite aware of, my Lord, where on appeal, at the end of the day, after the appellate made decisions, the accused in those matters were sentenced to correctional supervision, my Lord, and that is not to say that the court does not have a discretion to determine what sentence the court is going to impose at the end of the day, my Lord. But surely, if the court has been placed in possession of all the necessary reports pertaining to the facts of this matter, my Lord, there is a possibility that the court might come to a different finding to impose a long term of imprisonment on the accused persons before court. I would further refer the court to State versus Roeder, my Lord, where the accused murdered his actual wife. And in that specific matter, the appellate division also gave bail to Mr. Roeder prior to his sentencing. And the court is quite correct. The court has got a discretion, my Lord. But I submit that the court can find in this matter that there are
What was the bail in Roeder's case?
Sorry, my Lord.
How much bail?
My Lord, I cannot remember.
I'll
the
tell you
amount
about
of
it
bail.
because it came before me. Although it was in the Western Cape.
Yes.
Indirectly, it came before me in the unopposed motion court. Mr. Roeder didn't have finance. He had assets.
Yes.
And I think what he did, he said he's prepared to give a property that the value was X amount.
My Lord.
And that property then was bonded, and he said, well, it was unencumbered. And he says, well, the state said, no, we want money. So he said, all right, then you must allow him. That is what happened there.
My Lord,
it was in the millions.
that is the reason why I've referred to that specific matter, because I have taken instruction from my instructing attorney, Mr. Oakes, who is a conveyancer. And the tender is that doesn't matter what amount the court imposes pertaining to a bail amount, that the property is available and that Mr. Oakes will see to it that a second bond is registered on that specific property as soon as possible, my Lord.
From what you read, I understand he estimates the property to be 4.5 million and it's encumbered to about 900,000.
Yes,
so
Lord.
equity is in there.
That is correct, my Lord. So that is the actual tender which the defense intends
Well,
making,
I
my
suggest you get your ducks in a row. You get that from the bank and this type of thing. I've had a similar situation in another matter, similar to this. And then the court makes an order, and they can't get the stuff. Then they come and they want to change the goalpost.
My Lord, it is
Then
my-
they say, no, we can't now. The property can't be done this. Now can we change things? You know, if that is what it is, make a proper investigation in this regard. And if you come up and tell me then, and the bank says, well, we're prepared to give 2 million or whatever the case is, then there's something concrete. I'm not going to work with pie in the sky.
May I just get an instruction
Yes,
from
take
my
an
judge?
instruction.
My Lord, the alternative, with the greatest of respect towards the court, if the court is inclined to find indeed in this matter exceptional circumstances, my Lord, and I submit pertaining to section 64A, B, C, D, and E, there's really nothing pertaining to that has been placed before the state. And it is so that your Lordship has a discretion, my Lord. Our our request is then for the court to set a high amount of bail, my lord. And the accused must then make the necessary means to raise that amount.
And the next thing is there will be a ground of appeal. The court didn't apply its mind. It came to a conclusion. You know what? I'm not doing this from yesterday.
No, I know that, my lord.
I've been
but-
21 years on the bench.
But it's
So experience. You don't buy at Checkers or at Woolworths.
yes, my lord, I agree with the court, but
So
you must also
I am saying the onus is on you. If you want to do this, come with something concrete and I will consider it. I haven't made up my mind. It doesn't help you to say, fix a figure. I fix a figure of 5 million, let's just say. Then the first thing you'll do, one ground, where did the court come to the figure of 5 million? The man doesn't have it. Then you go to Budlander. It's beyond his ability.
yes, my lord, but
This is your case, you must make
Yes.
it out. In a bail application that was here before me, you can ask her. The woman that put in an affidavit, she had property worth 4 million which she can liquidate. I said, fine. I fixed bail in 3 million. The next thing is they took me on appeal to the SCA. And the SCA ruled I was right. Because she said she's got 4 million. Now, on what basis do I fix bail if I don't know what his assets are?
well, my
Your
lord,
client is saying he's unemployed and he's only got 400,000.
well, he also indicated that he's got a BMW that's worth 850,000 rand.
And he
That
owes
can
on
be
it.
sold.
So what I'm saying to you is, get these values, find out what you can realize, and come back. And then you give it to the state and say, look, from the property we can get X amount. From the vehicle, if we were to sell it to the bank and whatever the case is, we will realize so much. You come back and we can hear it. I'm not going to suck out figures from my thumb. I'm not the applicant. The onus is on you.
My lord, I fully agree with that, but at the end of the day, as the court has got a discretion whether or not to grant bail, I submit that the court has also got a discretion to fix a reasonable amount of bail, my lord. And surely, my lord, that the court can do that.
You know, in the Beertger case,
without any problem.
please go and read the Beertger case. It's reported. I think it's 2013, the judgment. I recall it distinctly. Similar situation. A lady was charged for killing her husband. They rushed him. They went to the Supreme Court of Appeal. When I remember me having to fix a judgment just before Christmas. And I did it. It's reported. I suggest do this in a proper manner. I'm not going to do it piecemeal.
Yes.
That's what I'm suggesting. But if you want to put the ball in my court, I'm happy to play the shot. But the choice is yours.
My lord, may I just get an instruction?
The choice is yours. I can't be fairer than that.
My lord, the fact of the matter is that the financial position was placed before your lordship. State doesn't oppose the bail, and that is also a further factor. And once again, your lordship is quite correct. Your lordship has got a discretion, especially in a Schedule 6 bail application. But the state is not opposing bail, so we will take your lordship's guidance. But saying if your lordship, and that is the whole purpose, I submit, of a bail application as well.
Mr. Benhard, you are shadow boxing with me.
My lord, no.
I'm telling you, I gave you an option.
Yes.
If you want me to make a ruling, I'll make a ruling. I've made a suggestion to you. You're telling me about the property. Get back to me with,
We will do so, my lord.
if you want to.
We will
I'm not
do
putting
so.
a gun to your head.
We-
The choice is yours. You can say, no, you make a decision, I'll make one.
We will-
But if you come back with concrete before me, I don't know what the property value is. He's giving me estimates. I don't have actual values from valuators. I don't know what the equity in it is.
My lord, we will then do so. We will get the necessary information and approach the court with that.
When you get the proper valuations and things, and you've got a proper affidavit, then I suggest you really send it to Mr. Mokhotsi before we get here. so that he can see it, and then on the next occasion, if they want to oppose or whatever, they can do so.
My Lord, can we just get an indication from the court? Will the court be available in the next 2 weeks or so, my Lord?
Well, I am around. But you got to ask those people there. They also have lives.
My Lord, if we maybe
So-
get a suggestion, my attorney just indicated to me we will most probably be able, today is Tuesday, maybe get everything before Monday furnished to the court after the prosecution the same. Whether or not the court will be available on Monday perhaps, and my learned colleagues for the state and excuse number 2's counsel, my Lord. Then we can maybe proceed with the application for bail on Monday.
Mr. Makotsi and his colleagues.
My Lord, we have other commitments. We will try and make ourselves available for this one. We'll see how we.
If you say Monday, I come here on Monday, you don't have the information ready, don't tell me I must come here by Christmas. I'm not a yo-yo. So I suggest, rather than just in desperation say Monday, rather use a reasonable period. I suggest you give valuations, what the equity in the property would be, and whether the bank would be prepared to register a second bond. I don't know. And I can't see that happening in 2 days.
My Lord, once we
Yes,
may I approach.
certainly.
My Lord, may I just approach the
Yes.
statement? My Lord, may I just approach accused number 3?
Yes.
Thank you.
Isn't she? Okay, we'll be ready.
My Lord, may I just approach my colleague? My Lord, we have all agreed if it suits your Lordship, the 11th, then that would be next week Thursday. We also undertake to furnish the state with the necessary documentation as soon as we receive same, but not later than Monday, the 8th of December. Thank you.
Mr. Masia, the date suits you.
The date is suitable to me.
Mr. Makoti and others.
Basically, the court suits me.
Now, I'm told they'll give you the documentation on the 8th.
My Lord, what he said to us is that those documents will be finished with those documents as soon as it's reasonable.
As soon as it, but not later than
Not
the 8th.
later than the 8th.
So you'll get it at the very latest 2 days before the 3 days before the hearing.
That's what I was taking up with him, that he should not send those documents in the morning of the day.
What I want to now know is, when that is handed up, am I going to have to sit and hear arguments de novo again?
I don't believe so.
No, because I tell you what, as far as I'm concerned, the arguments are here. It's for me to ponder over this, and I can then start preparing myself. I haven't made up my mind whether I'm granting bail or not, but if I'm going to grant bail, then if they have those documents, then I, make the order. But I have to prepare judgment. Otherwise, I come here on the 11th and I will reserve judgment to the new year. Because everybody does what they want to, and the court is just to tag along. So I want to know now whether you're going to argue this de novo again.
From our side, no, my Lord. It will only, or if there is an argument, it will be centered around those documents.
Whether the state would be satisfied with the so-called security that they brought.
Oh, correct.
That's all.
Correct.
Mr.
I confirm that, my Lord. I think the only issue will be the amount and pertaining to the securities.
No, it's not the only thing. It's for me to determine.
No, but
They have,
pertaining to us.
You have argued. He's argued. I haven't made up my mind.
Yes, my Lord.
So I will now go between now. After
will,
Monday, I switch off when I leave here. Monday I'll start thinking again.
there will be no further arguments on the merits
Right.
of the application.
Okay, then that's fine. Okay, be that as it may, is it then necessary for the accused to want to be here in court?
Submit, yes.
Why? Because whether I grant bail or I don't grant bail, bail can always be paid there, wherever they are detained. Do you understand what I'm saying?
No, I understand, because I know the logistics are very complex when bringing people that are inside custody. So the court, I don't mind that we can proceed in.
All that will happen is the court will give a judgment, will determine whether it's granting bail. If it says it's going to grant bail, whatever the amount is, the family must be here, they must have the money, and the order, they can go downstairs here and go and pay it. And then they will give them the J, whatever number it is, to release them if they pay it.
As your Lordship please.
Pertaining to accused number 3 or applicant number 2 in this application,
Yes.
it is my submission pertaining to him. Time is of the essence in order to get the necessary documentation to the state and to furnish your Lordship the same by next week, the 11th. Instructing attorney has indicated to me that it's going to be very difficult, almost impossible, if he is in prison, in Johannesburg prison, to get him to sign the necessary documentation and or to accompany him to the bank and to sign all the power of attorneys and documents in order to...
As I
do
said,
that.
I've been in practice for 30 years. Your
Yes.
attorney is not someone that is inexperienced. There's a thing known as a power of attorney. He signs a power of attorney, whichever bank it is, he authorizes them. Alternatively, if he doesn't want to do it himself, he gives the authority to, I think he's got a living partner or something. Then he gives it to her. And he can do one on his own. He can sign to the bank and he can give one to his partner.
My Lord,
Then the partner can do all the work here. So you know what? I've been around. I know these things. I've been around the block.
My Lord, there's that specific request to the
Well,
court, so the
you know
court
what?
must make a finding on that, my Lord.
You know, these are these are simple things, you know, which can be easily overcome. So I suggest, you know what, if you want, I'm quite happy for them not to take him immediately to the prison, Mr. Oakes. You can go and see your client downstairs and I'll make an order. Where's the sergeant? What time does your last taxi leave here? 3 o'clock. Please keep accused number 3 and them here till after lunch, so that Mr. Oak can do all the necessary paperwork and for him to sign. You give me that assurance, sir. Thank you, I appreciate that. Right. Now that is done. Have you people arranged a date for... What is the date, Mrs. Kabini?
It's the 11th.
No, that is for the bail thing.
Yes, sir.
So I'm not postponing it there. I've got to postpone the trial to a certain date for these gentlemen who want a postponement for getting reports.
My lord, in as far as the date for the sentencing is concerned, my lord, that needs to be arranged by the office, and since we're not given an opportunity to adjourn, we'll not make
Okay, so I'm just going to postpone this matter till the 11th, and then I'm going to make an order that they be brought here.
As the court pleases, my
So on
lord,
that
my
date,
lord,
will you please see to it on the 11th you have a trial date?
as the court pleases, my lord.
Is that in order?
That is in order, my lord.
Right. Mr. Engelbrecht, yeah,
My lord,
he's saying something else.
yes, my lord. In as far as the location, my lord, of the court,
Yeah,
it is the state's request,
yeah.
my lord, that when we return for sentencing proceedings, the location of the court should go back to Benoni. It is the state humble request for 2 reasons. The first reason is that this matter emanates from Benoni. The second reason is that the deceased residential area is in Benoni.
Ms. Kabini, I hear what you say,
Yes.
but on the last occasion I had to suffer the indignity of speaking to counsel in corridors.
As the
I wasn't given an office.
as the
I'm not prepared to work under those circumstances.
my
It
lord,
might be your request, but you see to it that I have an office, and you see to it that I don't consult and speak to 10 and 12 lawyers in public places and everybody can hear.
the challenge
I'm not going to run my court like it's a tavern.
the
And
challenge
if you want me to do that, I can tell you I will not comply with that. The last time, I've never been so humiliated in my life that I had to ask these advocates who came there. We were standing there in a passageway and everybody was talking. Do you think that that's a way to conduct a court? Mr.
No, ma'am.
Mr.
No,
Mr.
correctly.
So I'm not prepared to come there and then I must be told I must check in with somebody here.
as the court pleases, my lord, the challenges that we experience on the trial. will
Well,
be-
I'm not prepared to undergo that challenge.
it's not
I want to be treated, I treat you people with dignity and I want to be treated in turn with dignity.
As the court pleases, my lord, the treatment that this honorable court endured on that day is regrettable, and in as far as we are concerned, it's not on the part of NPA, it's on the part
I don't know,
of justice.
I'm not putting blame to anyone, I'm not saying it's you, I'm not saying whoever it is. I am saying I will not work under those conditions.
But it's not going to happen. I'm giving this court assurance that that is not going to happen, my lord. So it is the
And why
state-
should I come to Benoni just there to postpone a matter? On the 11th, it's going to be postponed.
No, my lord, I was not talking in terms of the 11th. I was talking in terms of the sentencing proceedings in advance. I was making that application.
So that is for the, once the case is postponed, when they have arranged a date for the reports and things.
As the court pleases, my lord. On the 11th, my lord, we can as well come back here. The state does not have a problem with that, but I was making the application in advance for the sentencing proceedings that the location of this court should go back to Benoni, and we will ensure, my lord, that the court does not suffer the
First and
humiliation.
foremost, I've got nothing against Benoni. I think it's a very nice place. But the court is small. You hear? The public is saying so. That is the reason I'm quite happy you give me the facilities and the public. In Benoni, the people are standing in the corridors in the court. People are walking in and they're bumping into each other because it's packed to the rafters. But if that's where you want it,
Yes.
we will have it there.
Thank you, my lord. Thank you.
But I'm telling you now, if I come there, I don't have an office, and I don't have the facilities. I get in my car, I come home, you'll do the trial. I'm telling you this now, because the last time you were not even there, you were before another judge. And I had to speak to everybody. I don't know if Mr. Divana and Mr. Mokhotsi were happy to speak in corridors. I don't know. Maybe they were happy, but I certainly don't think it's proper.
It wasn't proper.
Yes.
Thank you.
Right. Gentlemen. So we agree on the 11th we're coming back to Johannesburg. Is that right?
Yes.
Mr. Engelbrecht and Mr. Stander. This matter is postponed to 11th December. I take it you followed the proceedings, you know why it's postponed to the 11th.
Yes,
Or do I need to explain it to you?
I understand, my lord.
Right. You have been previously out on warning or whatever. Two of you will be kept in custody until the 11th. On the 11th, depending on what is handed up to the court will then make a determination regarding whether you should be released on bail or not. Both of those.
Thank you, my lord.
Okay, so the 11th is only for the court to make a determination whether you ought to be granted bail or not. And for Mr. Oakes and Mr. Weingaard to give the state certain documentation. Are you also going to reconsider your matter or not? Or are you done?
My lord, our circumstances have indicated before that they are different.
Right, so you're not going to, there will be no...
If there's any change or things that we may get from the applicant, we shall
Yes.
do so if necessary. But it
Thank
still
you.
relies on his employment salary.
Thank you, Mr. Masood.
Okay.
All right, so you are remanded in custody until the 11th of December.
That's the case.
Leaflet. You must keep all this. This goes in the file. Sergeant, please help Mr. Oakes.
Thank you, my lord. I was just trying to make arrangements for that. I thought-
I don't want him to come downstairs and then they say they've taken them away, because then it's just going to be, please assist this gentleman.
Yeah, we'll wait for you.
Thank you. I know it's Christmas, everybody's in a hurry. Okay. After you take this, I don't want to drop anything. And thank you, the court adjourns.
Long live the undying spirit of Caiphus Nyoka, long live! Long live! Long live the undying spirit of Moses Nyoka, long live! Long live! Viva los Center, viva! Viva! Los Center, viva! Viva! Lukman, viva! Viva! Enka! Enka! Abraham!
Good morning.
everything we've done.
Is it? Oh, you're in court today.
Telephone number.
Yeah, probably I will.
Yeah. Can you write that down? Yeah, I'm coming down. Yeah.
Okay, ma'am. We get a reaction from who?
All right.
We get a reaction from?
The sister.
Where is she?
She's coming. You'll see me at the camera, ENCA camera, because I want to do an interview with the family now. All right, cool. To her after speaking to the family representative.
And why did they leave now?
Alex. Alex is out of my city, Mam's over the Mamudimu. Oh, he bumped over the night celebrate. And not about the head. Oh, and then with her no walk around the city. Come closer. Please come here, Ma. Sorry to break. Come here, Mama. Here. Yeah. Yes. She's fine. I'll hold it for you. Okay. Please go back. Yes, thank you.
They are making noise.